Welcome to Fight for Justice this week. I'm Freeman Fite. I'm here with my father, Arthur Fite, and we have a special guest this week, Jesse Evans. And he has got a great background in property, actually wrote the book on property and remedies for the state of Alabama, and we'd like to welcome him to the show.
Thank you. Thank you. My pleasure to be here.
Well, thank you for coming.
You know, Arthur's an old friend of mine. It's always good to see old friends.
Absolutely.
It is, and by the way, I'll remind our audience, this is your first time doing a TV show for a law subject, isn't it?
It is. This is the first time, so please bear with me if I don't do right.
Why don't you start just by telling us a little bit about yourself? I understand you graduated from law school in 1979.
Yeah, I did. I got out in '79, and I've been practicing for, I suppose that makes me around 35 years now. And mostly I do real estate and business type litigation. I do a lot of land use work, a lot of financing type litigation and those types of things.
Have you done that for the entirety of your career? Is that something you started
Well,
specializing
pretty much.
later?
I mean, I've done other things naturally over the years. I've done some transactions work from time to time. I've written wills. I've done a little bit of all of it. But mostly that's been the predominant area.
When you said transactions, tell our audience what you mean by transactions.
Well, transactions like I have never done any, say, residential housing purchases and financing, but I have done some commercial work for commercial lenders where, say, for example, shopping center type financing and leasing and some things of that nature.
Okay. Now, as I mentioned in the intro, you actually wrote the book on property and remedies.
Well, I wrote a book.
A book.
A book. There's a couple out there that.
Well, it's actually sitting on my desk at the office right now.
Well, thank you, and I'm sure my publisher thanks you for it.
Well, why don't you tell us a little bit about that? What that process was like?
Oh, it was long and drawn out. It took me about 3.5 years to write it. And that was back in the early '90s. It's in the 5th edition now, and it's a constant work every week on it type thing.
And I think when we were talking about in the pre-interview, you told us you're still spending about 15 to 16 hours a week on it.
Probably so. I work generally on the weekends. I have to spend most of the two, Saturday and Sunday on it. Still a lot of work.
And so when you're, is that just to update the book to make sure it's current with current laws and case laws?
Yeah, update, and then occasionally, every 5 or 6 years or so, there'll be a new edition that'll have to be prepared and the like. It's quite a work. It's gotten to where it's a little bit on the overwhelming side.
And the book is about the different types of remedies and property situations.
Primarily about property litigation. There's a lot of things that you could. If somebody were going to sit down and write a book about all the Alabama property law that there is, it would be 5 or 10 volumes at least. This is a little bit more narrow because it deals largely with, it's confined to litigation. Like, for example, there's not anything in there about condominiums or the like. There's nothing in there that you would find about how to close a loan or anything of that nature. But you will find things like mechanics and materialman's lien type litigation.
That's actually why I pulled it out the other day.
Well, and there's stuff like condemnation litigation that's covered by it. There are 3 or 4 chapters that are kind of background chapters to the book that kind of, it basically started out as a group of notes from when I was teaching law school, and it has evolved into this now.
Well, I think the first topic we want to discuss tonight for the audience is mortgages.
Mortgages.
Yeah, so why don't you tell us what a mortgage is and how does it operate?
Well, mortgages that's something that most everybody in around uses sooner or later for any number of reasons. Primarily, I guess the primary reason that people would want to mortgage a piece of property basically is to acquire it, to be able to borrow the funds to buy it, and once you do that, then you're going to have to give that lender some type of security, and the way you're going to give them security is by giving them a mortgage. Now, technically under Alabama law, when you give a mortgage, some people call it a lien. There's some decisions that say it's a lien, but Alabama is what we call a title state. And that means that if you go and buy a piece of property and you mortgage that property to a lender, you will take title to the property, but then when you execute that mortgage, you pass the title to the lender, but that title is subject to being divested or to come back to you, if you will, once that debt is paid, and once all the other obligations of the mortgage are paid. Now, a mortgage secures a lot more than just money. It secures the obligation of the borrower to maintain insurance and to pay ad valorem taxes and things of that nature on the property.
Let me ask you this about that. Does the mortgage guarantee the lender that you'll keep the property up, maintain it?
Typically, the borrower in the mortgage will make covenants in that mortgage that he will keep it in a good and reasonable state of repair during the term of the mortgage. And one reason for it is, the mortgage is basically the lender's collateral. And if the borrower does not keep that collateral up, then it would be impaired, and the lender could quite likely lose the value of its collateral. And so, there are typically obligations in the mortgage to do that.
And we've got basically, you've got 15-year mortgages, you've got 30-year mortgages. Are there any other types other than those?
Oh, there are multitudes of mortgages. I mean, a mortgage may be due in 5 years. You may have, options to extend them. You may have amortization periods. I mean, they can take all
balloon
shapes
payments.
and forms.
There's all kinds of different.
They can take all kinds of forms, and in particular in the commercial area, they're more flexible. Generally, I mean, you have certain governmental programs that back certain types of mortgages, like your FHA programs and your VA programs, or 20 and 30-year mortgages and the like. But your commercial lending, particularly as a result of the last, say, 8 or 10 years in the market, that has changed a fair amount.
Well, you're free to pretty much create any kind of mortgage terms you want, aren't you?
Well, the borrower is not particularly. The borrower is usually going to be getting what the borrower can get. The lender, yes. At least in the non-residential transactions.
We've only got a few seconds left, and I think when we come back from break, we're actually going to take it up with what is the default of a mortgage and foreclosures, and what your remedies are, and all that in the second and third segment. So hopefully you will come back and join us for the second segment, and we will see you in just a couple minutes. Welcome back to the second segment of Fight for Justice. I'm Freeman Fite. I'm here with my father, Arthur Fite, and our guest, Jesse Evans. We're discussing mortgages and remedies, properties, the laws that really regard these issues. If you have anything you'd like to see us discuss in the future, you can email us at questions@fitelawfirm.com. And if you need any help with any legal matters, you can reach us at 256-231-9330. Now, Jesse, when we left off, we were talking about mortgages, how they operate, what they do, what the purpose of them is. Let's talk about default. What would put you in default of a mortgage?
Well, typically a default is going to occur if a person doesn't make the payments in accordance with the terms of the mortgage. Defaults can occur from other things: failure to keep insurance and maintain the insurance. Default could occur for failure to pay the ad valorem taxes on a parcel of property.
I asked you a minute ago about maintaining the property. That could be a default too.
Sure it could.
But I wonder how often that doesn't occur very often. I've never
Typically doesn't, because if someone's going to invest and obligate themselves to make payments, then they're going to keep the property in pretty good shape. So it doesn't happen very often. But depending upon the level of sophistication of the transaction. For example, you may have commercial transactions that are highly sophisticated, and you may have all types of obligations. For example, the borrower may have the obligation to provide financial statements to the lender every year. They may have obligations to do other things, on a periodic basis to allow the lender to come in and do inspections and things of that nature. And a lot of times, any breach of any of these promises that are made in a mortgage, and the mortgage is just a contract, and if there's a breach of that contract, then the lender can then declare a default if the mortgage says they must formally declare it, Or in some instances, they can just move forward and default it and start exercising their remedies without there being a formal declaration. But that depends on the language of the mortgage. What does
Let
the
me ask you
mortgage
this
say?
about, if you have a property destroyed by a tornado, as we've had in Calhoun County over the years, what does that typically do to the status of that mortgage?
Well, let's suppose you've got a house, and let me see if I'm understanding this, what you're asking me correct. You've got a
collateral's
house
destroyed.
that gets destroyed, total destruction. It's gone. It's either got to be totally rebuilt or just sell the vacant lot. In that instance, as a general rule, to the extent of the unpaid balance on the mortgage, the insurer who was carrying the casualty insurance, and assuming that there's no problems with the insurance and the like, the insurer would owe to the lender the amount of the debt and whatever charges might be applicable and could be charged under the mortgage. And then any excess would be paid over to the borrower. But now, bear in mind that insurance generally will not cover the value of the land. It will only cover the value of the structures and the improvements in the personal
And
property.
then in that case, you get into some disputes with the insurance companies about whether they're gonna allow you to rebuild it or whether you wanna rebuild it, or just pay it off and you get the balance if there's any.
You have we've had a lot of disputes like that in Jefferson County as a result of the 2011 tornadoes that came through Tuscaloosa, Jefferson, Coleman, and I think they came over here as well and came up through Etowah and so on. There have been a number of disputes over that about the level to which, or should the structure be removed, can it be repaired, and the like.
And in some instances, you could be in default just by missing one mortgage payment.
You could. That could happen. But a lot of that, most lenders now are a lot more flexible than that. Time was, obviously, that was the situation. But there's a great deal more flexibility as a result of some of the federal regulation we have on lenders now. And the like. And a lot of the mortgage documents themselves say that a lender must give notice of a default and give a borrower a right to cure that default. In other words, if you miss a payment, they've got to notify you, and then you have a certain period of time within which to come back and make that payment and get caught up. So
I had a case years ago I want to ask you about. The lender was an individual rather than a mortgage company.
yeah.
And there had been a history of the borrower making late payments. It'd be 15, 20, 30 days late. And the lender, the individual, would accept them late. The long history of that. They then tried to foreclose. Then the owner tried to make another late payment, and they wouldn't take them. And the court ruled the lender had waived his right to the foreclosure at that point in time because of a history of accepting late payments. Have you seen that?
I've seen that situation. Typically, you got to look at the facts and circumstances, obviously, of each case, because a lender also has the right to say, okay, I know I've accepted these late payments for this ever how many number of years, but I'm going to insist on strict performance of this mortgage in the future. Yeah. And if a person does not perform, then, in that instance, even though there may have been a waiver at one time, the new, his notice that he's going to require strict performance may obviate that in some instances.
I wanted to ask you one other thing that people read about here. Florida. Florida is a different process.
Totally different process in Florida and a lot of states when it comes to the foreclosure after the default. Foreclosure is the remedy that the lender exercises once there is a default. Say if there's a failure you miss 5 or 6 payments, there's notice given, make the payments, there's no cure that occurs, then the lender first got to look at his mortgage documents and say, okay, what does this document tell me I can do? Once they look at the document, make an assessment of the remedies, there is, under Alabama law, the right to use what we call a power of sale. That is, the lender can publish a notice of default, notice of a foreclosure sale, in a newspaper of general circulation in the county, and then after a certain period of time, the lender can simply put the property up for public sale at the courthouse. And when that happens, generally the borrower's right in the property is cut off. Now, one thing that's important about that is this. There's a thing that we call the statutory right of redemption, and maybe we'll get into in a few minutes. But if a person suffers a foreclosure and they don't, typically the lender is going to make a demand for possession immediately.
I'm going to have to cut you off right here because we only have about 10 seconds to go. But when we come back, we will discuss the different types of foreclosures, the process for those, sale at the courthouse, and everything else. See you back in a couple minutes. Welcome to the final segment of tonight's show, Fight for Justice. When we left off, we were talking about the different type of options that lenders have for foreclosure. Why don't we pick back up there?
I think I probably to some degree avoided Arthur's last question about the difference between Alabama and other jurisdictions. Alabama is a power of sale state. I kind of had gotten into that. That means you look to the mortgage, then you have the right to publish and foreclose and sell at the courthouse steps. Optionally, or another method of foreclosure in Alabama is what we call judicial foreclosure. And that is that a lender can file a lawsuit to foreclose. Now, and ask the court to order the foreclosure in accordance with, typically there would be some publication once a week for 3 consecutive weeks or so on. Many jurisdictions do not have power of sale options like we do. Like, for example, I don't think the state of Florida does. They have something that's more akin to our judicial foreclosure situation. And, you know, as a result, we've heard all of this over the last few years about all the problems in Florida with the foreclosures and this and that and the other. Alabama has not experienced the problems that other jurisdictions have, largely because of the process that Alabama has and the statutory scheme that we have for foreclosure in Alabama.
Is that one of the reasons that you hear about people moving to Florida to file bankruptcy because of their different laws and their
probably so.
homesteads?
But if you're looking at a mortgage, it's not going to really help you that much because the mortgage is going to be enforced in accordance with the law of the state where the property is. But say, for example, when the property is sold at foreclosure, if the property doesn't bring an amount equal to or greater than the debt that is owed at that point in time, then the lender can then sue the borrower for the difference in what the property brought, what we typically refer to as a deficiency type judgment. Now,
Okay.
But then, you know, all is not lost once the foreclosure occurs.
If it brings more money at
If
the
it brings
foreclosure.
more money, then the borrower would be entitled to that excess. Or if you had junior mortgage, second mortgage,
They get it.
they would get it.
But I rarely ever see banks bid more than what they're owed on the property.
Typically not, except by mistake.
Yeah, that's happened.
It has happened. I've seen people make mistakes, and that can happen.
Yeah. Now, you were asking about Florida. I really think what he's talking about is in Florida.
Homestead exemption
You have no.
for bankruptcy.
Yeah, you have a greater homestead exemption in Florida.
Yeah, Florida has a much broader set of exemptions than Alabama does.
Larger. I think in Florida it's almost unlimited.
I'm not certain, but that wouldn't surprise me. You know, I know the state of Texas has some very broad exemptions.
What that means for those watching is that if a fellow bankrupts and he's got $100,000 equity, he gets to keep it in Florida.
Possibly so.
Whereas Alabama, I think the limit's about 5,000. So once you exceed that 5,000, your creditors get it, but not in Florida.
I don't know that much about bankruptcy. My knowledge largely comes from having lived on the verge of it for most of my life, but I think that's substantially correct.
All right, and what kind of rights does the property owner have, after a foreclosure? I think before in the last segment you mentioned the right of redemption.
Once the lender forecloses, the lender is typically going to make a demand under a state law that we have. It's actually Section 65280 of the Code of Alabama that says that if a person does not vacate the premises within 10 days, then they lose certain rights that they have after the foreclosure. Now, those rights basically are a statutory right of redemption. The borrower loses all of his property interest at the time that he suffers the foreclosure. When it's knocked off at the courthouse steps, the property rights as such are gone, and a personal right arises. It can be assigned to someone and the like, but it's called a statutory right of redemption. And you can redeem from that foreclosure within 1 year if you do not lose the right of redemption by failing to vacate the premises within the property within the year. Occasionally people, unable to move for a 10-day period after the foreclosure. And in that circumstance, they lose the right of redemption.
Well, talk about this. I've run into this. I know you have. You have a foreclosure, and they bid in what's owed on the property, but they can also add to that attorney's fees, other expenses.
Yeah, attorney's fees. You're talking about? Are you asking me what can they bid at the foreclosure, or what would it cost to redeem?
Either one. Either one.
Well, what can be bid at the foreclosure is going to largely be dictated by the terms of the mortgage. Like, for example, any unpaid insurance premiums, attorney's fees, the amount of the debt, any accrued interest, any late charges, and the like.
And you come back 9 months and you want to redeem it, and you've got the money. What can you have to pay? What could you have to be required to pay to get it back?
You could be required to pay the bid price at the foreclosure. Mm-hmm. You could be required to pay any debt, any amount of the debt that remains outstanding. You could be required to pay any insurance premiums. You could be required to pay any taxes that have been paid. And you could be also required to pay the value, not the cost, but the value of any permanent improvements made to the property.
After foreclosure?
After foreclosure.
So if I add a bedroom to the house,
well,
would I have to pay for that?
What is actually a permanent improvement that can be charged in connection with the right of redemption is a little up in the air. It's got to be something that's pretty well consistent with the character and nature of the property. It doesn't have to be a repair as such, but I doubt you could get away with a $60,000, $70,000 swimming pool by the same respect, because it is an improvement, but it is a permanent improvement, but it's not something that's reasonably necessary for.
The right of redemption is something that someone, if you're going to go buy a piece of property at a courthouse at a foreclosure auction, that right of redemption is something you better be pretty familiar with, because that can come back and.
It is, because you could buy it, and you're going to buy it subject to that right of redemption. And there's a great deal of debate that has occurred in Alabama over the years about that right. At one time, the right extended for 2 years, up until I believe it was either 1969 or 1972. The period was shortened to 1 year. The legislature shortened it at that period in time. But some people say that it impairs the value, what you might get at the foreclosure sale.
Let me interrupt you and ask you a question. I know a lot of people wonder about tax sales. You go to the tax collector and you pay the taxes because they're overdue. What happens to the title of that property when you do that?
I'd like to be able to answer that question here, right now. But the best way I can answer it is that when I first started practicing law, I had a partner who was in his 80s, who was one of the most renowned property lawyers in Alabama, who wrote an article, and the first sentence said, I had a very good client who had made a lot of money in business, and he unfortunately decided he could make more money dealing in tax titles. So by that I mean that is it's an extraordinarily complex, convoluted world to get into.
You don't do that,
And I think real quick, because we've only got about 20 seconds left, you said you lose your right of redemption if you don't move out of the house within 10 days.
That's correct.
I think that's something the audience would.
Yeah, it's very important. Very important that you.
Yeah. Well, I think we've reached just about the end of the show tonight. We want to thank Mr. Evans for coming in. I'd like to thank Dad for being here, and we hope you'll catch us again next week.
9:30 on Wednesday nights.